All right, so here's the deal. We could spend the next 7 days talking about the Clarity Act and the regulatory considerations that the blockchain industry is facing. But as an act of mercy, my understanding is we have about 7 minutes to allocate to this. And I think that's probably more appropriate. I mean, especially for those of you that look at legislative and regulatory matters and think, and you just feel that they are mind-numbing, soul-crushing topics that by comparison make you look forward to your next colonoscopy. And I'm not going to fight you too hard on that. I think there's some logic there.
It's really painless, though. It's nice.
Well, great to hear. Now, that said, there is one point that I would like to drive home, and it's that for the blockchain industry, for the blockchain space, at least in this country, the boring stuff is important. The boring stuff matters. The regulatory uncertainty in general has been probably the most significant bottleneck when it comes to advancement of this industry in this country, when it comes to capital allocation, when it comes to encouraging entrepreneurs to start businesses. And again, that's ultimately what the Clarity Act comes down to. That's what we're trying to address here. But I mean, for those of you that might not be familiar, I mean, it's about Bitcoin. We're about 18 years in almost, and for the entire existence and the entire timeline of the existence of this industry, we have been living in a completely uncertain environment. I mean, basically, what we've had is a situation where the SEC has not told us how or under what circumstances they are going to regulate companies. They haven't told us what we need to do to not get sued. The CFTC has been involved, but hasn't been given any real authority. And there's a certain point where, I mean, this is going to stop the allocation of billions of dollars in capital. And that's likely what's happened. I mean, think about this. The Bitcoin ETFs that were launched over the past couple of years, I think it was IBIT, that might have been BlackRock's ETF. I think they reached 10 billion in assets under management faster than any other ETF of any kind in history up until that point. And to me, that tells me one thing. There was massive pent-up demand. And all of that demand was unleashed extraordinarily quickly as soon as the SEC simply stopped blocking the approval of these ETFs. Now, that's not a perfect analogy to the space as a whole. ETFs are a special thing, but I still think the analogy holds. I think if we get regulatory clarity to the point where allocating billions in capital into this space is no longer a huge risk, then I think the floodgates could open. And I think there is a lot of evidence to suggest that there are billions of dollars just sitting on the sidelines and ready to jump in. And that's really why the Clarity Act matters. All right, that's what this is all about. And to be fair, there's been almost no movement on the regulatory side when it comes to the SEC and the CFTC until recently. So over the past 18 to 24 months or so, we have at least received some guidance from the SEC and some guidance from the CFTC, which governs commodities, and even some proposed rules. And these proposed rules have purported to address this exact issue where when do we need to comply with SEC rules? When do we need to comply with CFTC rules? They have told us, but the issue is, as long as the legislative backdrop in Congress remains unclear or ambiguous, those rules could change. So it's helpful, it's incremental progress, the fact that they've told us finally after 18 years what we have to do to avoid getting sued. That, again, that's helpful. Don't want to minimize that, but we do need Congress to act, otherwise it could change the very next day. And that is ultimately what the Clarity Act is about. It's about memorializing the rules for the SEC and CFTC at the congressional level, so it's highly unlikely to change the very next year. So with that, again, we're not going to spend a lot of time on this because I know it's not necessarily the most interesting topic, but we should dive into the weeds a little bit, just so you have the information necessary to at least follow the news and figure out what's going on. And really, when it comes to the Clarity Act and what Congress is trying to nail down here, the technical legal questions, they really come down to when is a digital asset considered a security? When is it considered a commodity? When does the SEC have jurisdiction? When does the CFTC have jurisdiction? Is it one? Is it both? Is it, does it depend on the circumstances? And also what happens when a blockchain starts out centralized? So it looks a lot like a company, right? Where perhaps the founders, they issue a new token and they own 90% of the tokens. That looks an awful lot like a startup company with a majority shareholder. And in that case, especially if they're issuing tokens to raise money to further the project, I mean, to be fair, that looks a lot like you're just issuing stock in a corporation or LLC interests in an LLC. And sure, maybe securities regulations make at least some theoretical sense in that scenario. But what if the whole point is you want to start a new blockchain, and sure, it's centralized at first, but that's what it takes to get to the point where the blockchain matures, and eventually the goal is to become completely decentralized. Well, are you subject to the same rules and regulations the whole time through?
And it's a valid question. And fortunately, the Clarity Act, as it is currently drafted, because by the way, important point here is it has not passed yet. The House passed it last year. The Senate is marking it up as we speak, which is a good thing. I think that's happening literally this week. And this was news. So I think it's happening tomorrow. But again, the whole point is you need a path. I mean, you cannot be expected, if you're creating a new truly decentralized blockchain. The name of the game here is take nothing else away from this. It's ultimately, the reason why this has been a problem is because you cannot survive as a truly decentralized blockchain project and comply with current securities regulations. You can't do it. If you had to do that, if that was based on expectations, and then every time that you transfer a token from one person to another, you have to go through a broker-dealer. If you wanted to issue a token, you would have to essentially go through an IPO process or similar. So the name of the game here is just to realize that this is a new technology. The rules from 100 years ago don't apply very well, and maybe we should acknowledge that and move on. So I think with that in mind, we don't need to go into exorbitant detail, but, and in fact, would we have time for questions later if anyone's interested? Because I feel like this is one of those topics where you can go down rabbit holes, but obviously that only makes sense if people are interested. So frankly, I think this is a good spot to pause. There will be more attorneys, so don't worry. You'll still get, you'll still get what you came here for. But if there are any specific questions about the status of the bill or what needs to happen next or what would be good or bad, in my opinion, regarding what ends up in that bill, just feel free to ask. You can handle it that way.
And Bob, the other two lawyers first come up and you may ask questions again.
Yeah,
Sure, we'll ask the two.
sure.